How to prepare for a guardian ad litem investigation, part 1. If you're about to go through a guardian ad litem investigation, then you want to make sure that you watch this entire video for helpful tips on how you can set yourself up to get a recommendation in your favor. I'm Heather O'Connor from O'Connor Family Law. We're a divorce and custody firm that practices in Massachusetts and Rhode Island. We currently have 7 attorneys on our team, and we've collectively handled over 1,000 divorce and custody cases in the past 5 years alone, the majority of those being high conflict cases. I've been practicing family law for over a decade myself, and I'm also certified as a guardian ad litem, or what we call a GAL. So I have some tips for you based not only on my legal practice, but also based off of what was really helpful to me as I went through investigations myself of other families. If you find this video helpful, please show your support and hit that like button. This is one video in a series, so make sure you also subscribe to our channel so you don't miss the other videos as they're released. If you know someone going through a situation like this, feel free to share this video with them. And if you're an attorney trying to figure out how to help your client best, then this video is also for you. Before we get into the nitty-gritty of the actual investigation, let's make sure you understand what you need to know before the GAL is even appointed. The parties can either agree upon a GAL appointment, or the court could order it even over the objection of one or both of the parties if the judge deems it necessary. The judge will issue an order of appointment, usually based on what is requested. So knowing what to ask for is just as important as being prepared, because the GAL has to stay within the scope of what's allowed within that order. So here are 11 things to know about getting a GAL appointed so you're prepared in court and you set yourself up as well as humanly possible before the investigation even starts. 1. What type of GAL do you want? 2. How many hours do you believe the investigation will take? 3. What issues do you want the GAL to investigate? 4. Whether you want the GAL to make recommendations based on their investigation or not. 5. How many collaterals do you want the GAL to speak to on behalf of each party? 6. The date you need the report finished by. 7. The cap on the number of hours the GAL utilizes to conduct the investigation and write the report. 8. Who's paying for the report? And if it's being divided between the parties, how exactly is it being divided? 9. Whether you want the GAL to make a recommendation on the reallocation of fees. 10. Whether you want the court to allow the report to be emailed to both of the attorneys when it's completed. And 11, suggestions for the GAL appointment, or whether the court is going to be picking someone off the list. So we'll address all of those within this series, but in this video, we're going to address the first 4. The remainder will be answered in subsequent videos. So number 1, it is incredibly important to know what type of category of GAL you're requesting. And there are typically 3 types of GALs you will see. A Category E GAL, a Category F GAL, and a GAL appointed to waive or assert privilege. There's a few other types, but they're less common, so we're not going to discuss those in this video. The GAL appointed to waive or assert privilege is kind of like a subset of a GAL. This type only gets appointed if your children are involved in individual therapy and either of the parents want the main GAL to be able to talk to the therapist about what the child reports during therapy and what the therapist's thoughts and opinions are. I'm not going to focus on this type in this series, but I will do a video in the future that explains this, because this type of GAL is something that confuses a lot of people. So back to the Category E and F GALs. These are going to be the main types of GALs within your case. They differ in how they have to write the reports and whether they can basically interject their conclusions on the facts they've gathered during the investigation. Category E GALs must be mental health professionals, and they're able to formulate opinions and do analysis on the mental health of the parties and the children as well. Category F GALs could be mental health professionals, but they're often also attorneys who've gone through formal training. A Category FGAL is not allowed to analyze the facts or make opinions about the party's mental health. The way I find it helpful to remember the difference is that a Category EGAL can evaluate the situation, where a Category FGAL reports the facts only. E for evaluation, F for facts. Moving on to number 2. The number of hours you want the investigation to be completed within. The appointment form recently underwent some changes, and now there's 3 options the judge gets to choose from: 8 hours, 15 hours, or 35 hours. It might sound like a good idea to simply ask for the smallest number of hours here. After all, most of the time the parties are going to be paying for this, and less hours means less cost, right? Wrong. If the GAL does not have enough time allotted to them to complete their report, one of 2 things is generally going to happen. 1, you get a crappy report, something that won't do good to anybody. Or 2, the GAL is just going to have to file a motion with the court requesting additional time. And that's just going to increase the cost and is almost always allowed by the judge. So just make sure you get it right from the start. For the typical investigation of a contested matter, looking at issues like custody, parenting schedule, and usually 1 or 2 other problems, I've found that a good investigation and report really can't happen under 35 hours, which I think is why the court added that on as an option. If the GAL is only investigating 1 minor issue, like waiver privilege, or something like what town a child should go to school in, a lower number of hours might be appropriate. But having been a GAL, everything always takes much longer than you'd expect, especially if you want to submit a quality report. 35 hours sometimes really isn't even enough time to investigate everything that the parties want you to look at. Moving on to number 3, the issues the GAL is investigating. The appointment has boxes the judge can check off, but you want to make sure the judge understands what issues specifically you want the GAL to be investigating. This could be custody, parenting time, domestic violence, mental health or mental stability, substance or alcohol abuse, removal, parental alienation. The list goes on and on. But the GAL must stay within the scope of investigating only the issues that the court specifically references in the appointment. So make sure you tell the judge exactly what issues you want investigated. Saying, "We just want an investigation," is not going to be sufficient to make sure you're getting and paying for the investigation that you want. Also, if the case is already ongoing and in the midst of it, you, let's say, want to relocate with your child, you have to go back and amend your original complaint and then ask the court to order the GAL investigate that issue as well. You have to take that extra step because the GAL typically cannot do that on their own. And then the last point we're addressing in this video, number 4, the GAL recommendations. Believe it or not, you could have a complete investigation done, and unless the judge checks the box that orders the GAL to make recommendations, you won't get them. I don't think I've ever had a case where we did not want the GAL's recommendations, but do make sure you're asking the judge to order the GAL to make those recommendations. Let me explain why. A lot of times, the GAL report is used to help settle a case. The GAL, after talking with everyone involved, looking at the evidence presented to them, and talking to the kids and the collaterals, will make suggestions on what they think the best resolution of the case is, taking into consideration the children's best interest. If the facts as presented within the report back up the recommendations, then that should help you do a cost-benefit analysis of whether it's worth it to the client to keep fighting or whether you should try to use those recommendations to settle the matter. If the recommendations don't follow from the facts uncovered in the investigation, or if you can see a bias throughout the report and within the analysis provided that explains why the GAL is making the recommendations they've made, then you might have a case to bring to trial. But weighing out what you're fighting for versus all the costs, financial, emotional, physical, that all needs to be taken into consideration before you make that decision. I hope you found this helpful. If you did, please don't forget to hit that like and subscribe button. Stay tuned for part 2, where we'll get into what you need to do to be prepared for that GAL investigation. If you're overwhelmed and you need help in Massachusetts, feel free to reach out to our firm. You can call us at 774-314-4725, or you can shoot us an email at info@familylawma.com. Hope you have a great day.